Does freedom of speech exist in Canadian law schools?
There are still certain issues that are so hot, so contentious that I think law students in Canada quickly learn what those issues are and what sort of no-go zones are in terms of you can express.
Concepts with Shawn Whatley.
Welcome to Concepts. My name is Shawn Whatley. Today we have Tim Hagstrom with us. He's the National Director of the Runnymede Society. Tim completed a clerkship with the Court of Appeal for Saskatchewan. He's a lawyer, obviously, holds his JD from University of Saskatchewan, and he has degrees from Waterloo and Wilfrid Laurier as well. In law school, he served as president of the Runnymede chapter at the University of Saskatchewan, and he's also been a research assistant to Professor Dwight Newman, primarily on topics in constitutional law. His writing on the subject of administrative law has been published in the Supreme Court Law Review. So today we tackled what's going on with primarily with students around in the legal profession, but with a focus on the Runnymede Society. This is a society that you need to know about. It exists to draw people together that still believe and support ancient ideas that freedom of speech, freedom of expression, constitutionalism, the rule of law still matter, and that they should be discussed in a free and open way. So our conversation focused on what the Runnymede Society is, what does it believe, how did it come about, what is it trying to accomplish, and what are some of the issues that they tackle there. We had an opportunity to go deep into legal philosophy, constitutionalism. What is the rule of law? What does it mean? What are the limits of the rule of law? At the end of the episode, Tim was very gracious. He separated things out into a discussion of Runnymede and a discussion of his own personal case. But his own personal case is actually so important and so exciting. If you don't have time to listen to this episode or watch this episode, make sure you jump ahead and listen to Tim talk about that case in itself. It's in about the last 10 to 15 minutes of this podcast. And he gets into his personal case against the University of Saskatchewan that has to deal with its policies on decolonization, anti-racism, race-based scholarship. He had the nerve to stand up and question the evidential basis for race-based scholarship. So I'll let him describe what happened, but he is up to his neck in this whole issue of free speech, legal neutrality, race-based scholarship, critical social justice thinking on university campuses. And so his particular case, I think, is going to set a precedent for the rest of Canada. Really important for you to know about it. And I hope you get a chance to check that out. So again, even if you don't have time to listen or watch this podcast, make sure you skip ahead to that point near the end. Don't forget to hit like and subscribe. Consider becoming a Patreon member, and I look forward to hearing what you think about it. Welcome, Tim Hagstrom.
Well, Shawn, thanks so much for having me on.
Oh, my pleasure. I appreciate you making time. We were chatting in Edmonton just a few weeks ago, and I was saying that I thought I was at a Runnymede Society conference, but I'm starting to doubt myself. But the point of the story was that one of the keynote speakers, I was listening to him. I don't even know why I went to this philosophy of law conference, and which I thought was Runnymede. But anyways, the keynote speaker was giving his address, and I was aware that he was speaking English, but my goodness, I don't think I understood almost anything of what he said. So what the work you do is so necessary. Just tell us about Runnymede. Why was it formed? What drove you or the founders to create such a society, and what are you trying to accomplish with it? So go ahead.
Well, I'll have to speak on behalf of the founders because I became involved as the national director of the Runnymede Society in 2024. And the society had already been in existence for 8 years at that time. So it was founded in 2016. And if people want to learn a little bit more about the thinking at the time, there's a great National Post article that coincided with the announcement of the Runnymede Society. It was written by three people, Asher Honigman, Marty Subkoff, and Joanna Baring. So Joanna Baring was the first national director of the Runnymede Society. This National Post article is dated February 24th, 2016, if anyone wants to look for it. And the surnames of the three people I just mentioned are in the title. But it talks about how things had been happening in the law in Canada that really should have been sparking debate, but there wasn't a debate. And the example given there is a case called the Saskatchewan Federation of Labour against Saskatchewan. That was a 2015 decision by the Supreme Court of Canada. And what happened was when the Charter of Rights and Freedoms in Canada was enacted in 1982, it doesn't clearly include the right to strike, protection of the right to strike. It does have in Section 2D the right to freedom of association. And in a series of cases shortly after the Charter came into force in 1987, the Supreme Court of Canada confirmed that there isn't a right to strike in the Charter. But now we come to the Saskatchewan Federation of Labour case in 2015, and now the court says there is a right to strike. And unions can use the Charter to enforce it. So, and the court went so far as essentially to say the time has come to give constitutional benediction to the right to strike. So this really, whether you like the right to strike and you think it should be in the Constitution or not, the debate that needed to be had at that time was, who gets to decide what goes into the Constitution? Is it unelected judges, or is it through democratically elected officials, the premiers of the province, federal government, representing the will of the public? So that's an example, and there are other trends in the law that were going on at that time that justified taking a few of the people in the legal community who at the time were talking about this and sort of organizing them together and helping to kind of spread the message, helping to allow people on university campuses to find each other if they were questioning these things and wanted to find other people to question with them. So that's sort of the origin story of the Runnymede Society itself. I found out about the Runnymede Society when I started law school at the University of Saskatchewan in 2019. There was a student group on campus, and I had a sense that there were, let's call them taboo subjects in universities that really should have been the subject of rigorous interrogation and debate. So when I came to find out about the Runnymede Society student group, and I learned that they had a commitment, especially to intellectual diversity, to this idea that the rule of law is a principle that serves everyone and it can transcend political ideology. I was very excited and I got involved. I became a chapter co-president for 2 years. And I went off and spent 2 years articling, partly in a law firm and partly in a court, before joining Runnymede as national directors. That's kind of my introduction to the organization. It's been important ever since. I think today it's as relevant as ever. We're still a minority in Canadian law schools, even though there's a lot more people involved in Runnymede, and we're really having an impressive reach today, I would say. Overall, the goals of the Runnymede Society are to promote three principles that are at the bedrock of the constitutional system we've inherited in Canada. And those three principles are constitutionalism, the rule of law, and fundamental freedoms. And the way that as an organization we promote those principles, and I wouldn't just say promote, I would say we also protect them when they're tested or even threatened. The way we do this is by breaking open a discussion in order to have a rigorous interrogation. And something that's really special about the Runnymede Society is that even though as an organization, we absolutely stand for these three broad principles, when it comes to how they play out in legal matters or cases, specific issues of the day, we actually step back and we just set up the debate so that people in the audience can hear from reasonable people of goodwill who often disagree. As a rule, they tend to disagree and kind of come at the issue from different angles. And Runnymede doesn't sort of pick a winner among people in the debate. We leave it to people in the audience to form their own views. So it's been really exciting to be involved. I think it's such an important institution in the Canadian legal landscape.
So I'm cutting you off a little bit here. This is fantastic, and I'm scribbling down how come you didn't get canceled? You got involved and you still graduated. Open debate. So you're raising a whole bunch of questions. Can you speak to students getting involved right now in in the society? Do they maybe things have changed since Runnymede started? Mind you, you said 2019, so it's fairly new. Like, are you finding people get canceled for being part of your organization?
I can't think of an example of someone being canceled for being part of the organization. I can think of examples of people being canceled, and we can talk about that a little bit later. There are still certain issues that are so hot, so contentious that I think law students in Canada quickly learn what those issues are and what sort of no-go zones are in terms of you can express. And now, in terms of people being involved in Runnymede, there's often a desire to uh, assist people to get into those debates because we need to. Uh, Often it's a live legal issue that's being debated in a legislature somewhere in Canada or working its way through the courts. And yet students tell me that on campus, I can't talk about that. Or if I talk about it, there's a right answer and I can't question it, even though I don't agree with that answer. So we're quite tactful. Like we're not on campus just to stir up controversy for its own sake. And the students I get to work with are really quite thoughtful about, how do we skillfully broach this and encourage people to get into this, even though comfortable with it. So, we don't, we're tactful in how far we kind of expose people to new ideas.
And so you don't have to panic. I'm not going to ask you what the no-go zones are. And so no worries there. But so you've set up this fascinating situation where you are, on the one hand, aware that in order, I believe your word was tactfulness, in order to remain relevant and yet at the same time be tactful, you do avoid some of the hot button issues. And again, you can share it if you want, but I'm not asking you to share them. However, you make space for true debate. And so one of the things that, I guess I'm wrestling with it on this program, is sometimes we can hide behind the trees and not talk about the forest. So we can get way down into the minutia of constitutionalism or, what does the rule of law mean and how is that different from legal positivism and some of the things that we've been chatting about. But I also worry that sometimes that what I've called nerdiness or this desire to go deep is sometimes actually a cover to avoid drawing attention in a way that those hot button issues draw attention. So we're not going to touch the hot button issues, but we're also going to approach the whole area of discussion that is still not considered a hot button area by being so nerdy and so insider in our language that if anyone was listening, they'd be like, yeah, I'm not really sure what those people are talking about anyways, but we'll just leave them alone for now. So how do you be relevant? I'm struggling for a question here, Tim. How do you be relevant and edgy enough to provoke meaningful conversation, but while still avoiding getting in trouble?
It's a great question. And we do want to reach a lot of people. And today, we have quite a significant reach. We have a student chapter at 21 of Canada's law schools, which is almost all of them. And we're also expanding into undergraduate programs. Uh, The student chapters are on campus organizing speaker events. They're spreading the word and they're getting good attendance. So I estimate that for 2 years in a row now, approximately 1 in 10 of all law students in Canada went to at least one Runnymede event. And we do have to grapple with this question. I think part of it too, Shawn, is that the typical Runnymede volunteer is interested in these deeper questions. So if you get a group of Runnymede people together, they'll talk about legal positivism or the natural law tradition, and they're genuinely interested and can have good conversations. But it is helpful to connect it to specific legal cases or controversies that other people might be reading about in the news. And That way it has a broader appeal. And I think that is important because these types of questions really affect everybody. And especially among members of the legal community, this is the group in Canada where we want to be able to be reliable as experts and be able to see tests or threats to constitutionalism and the rule of law, to see them first, and then also to know what to do about them. And the other thought, just in terms of how can Runnymede have a broad appeal, part of what we're wrestling with is if we come out and just hit like a sacred cow topic, that can alienate people. And so we're just quite conscious of the fact that we're all human and there are certain beliefs that at a given time can be deeply personal for lots of people. And at the same time, those beliefs can connect to legal issues that need to be tested in the legal system. So how do we maintain those relationships and sort of win people over to dialogue and discussion and to demonstrating to them that it can be approached skillfully, or people are listening to each other, engaging in good faith, and never losing sight of respect for each other and civility in how they engage with each other. And I would say we have that track record, but today there are still a few sacred cows. I know you don't want me to name them necessarily, but
only if you're comfortable. If you want to, go ahead. But I'm not asking you to start sharing stuff that'll get you in trouble. So go ahead.
I'll give one because we've got our own podcast, Runnymede Radio, and we recently recorded a debate on residential school denialism, which I would put in that category. And this is a proposal. There's actually a bill before Parliament right now. It's past first reading, and the bill would add to the criminal code a prohibition against denying facts about residential schools in Canada or misrepresenting facts. And so we had a debate on it on the podcast. And there are campuses in law schools in Canada where the students would never touch that issue because it's so sensitive. And I think what we demonstrated on this podcast, though, is you can get someone who thinks this shouldn't be criminalized and somebody who thinks it shouldn't be, and they can actually talk to each other in a way where it just helps the audience member understand who's more persuasive to me, but also what would I have to view differently, or how would I have to weigh things differently to get to the other side of the issue, which I think is a really important exercise to undertake, because it's so important to engage in a debate like that and see the other side as still being very human and someone who has their own story, and not to perceive them to be further from me than they really are.
Yeah. I didn't even raise my hand here, and I promised you in the green room. I said, Tim, don't worry, I'll always raise my hand. I'll never cut you off. But now you're getting me excited. I can't support you enough in that approach, and this is something you said that we're human. I often just say, just be normal and don't be nasty. Just try to be nice, right? We're Canadians. We're supposed to be nice, and to demonstrate that we can talk about really, painful, loaded, hot button, whatever adjective we want to use to describe some of these issues. And the residential school one is a perfect one. But can we tackle these really hard issues that I think need to be tackled if we're going to live together and get along and have society function well? We have to be able to talk about these things. So I can't compliment you guys enough for that. I'm not sure again how to describe it. The ethos, the zeitgeist, the feeling or the approach, the attitude that you take with respect to these issues. So congratulations. But it seems like you were nodding at your case. I have it on the bottom of our list of things to talk about, but I think maybe we need to talk about it now. You're currently involved in litigation with the University of Saskatchewan, I believe, over free speech. So did you want to talk about that now, or we could leave it till later if you want, but go ahead.
Into it now. I want to be a little bit careful because so far I've sort of been speaking as a spokesperson for the Runnymede Society.
Okay.
And I mentioned that Runnymede doesn't take a position on particular cases and controversies. So when we talk about my case, I'm doing so in my personal capacity. And even that case is not an exception. to Runnymede Standing Back. So people in the Runnymede network or audiences and so on can look at this case and what I talk about and really come to their own conclusions. We're earnest about. But it does connect with sort of my own story of I personally believe in what we've been talking about so far about the importance of discourse, and just connecting to what you were talking about in terms of the legal profession just now. One of the phrases I heard in law school from a professor that stuck with me was a description of lawyers as healers of human conflict. And it's a type of phrase you might expect in like psychology or another field, where people have different expertise that's very useful. But there is something about lawyers needing to be capable of really stepping into any controversy and helping the parties reach some kind of resolution. Maybe later we'll talk about the importance of institutions in all of that, but we should really be expecting from the legal profession in Canada that it is made up of people who are capable of stepping in and letting cooler heads prevail, even when the parties are really passionately at odds with each other. A lawyer can step in and heal that human conflict.
Maybe we should get back on track then. I totally ruined. We had sort of a script we were going to follow, and I jumped right to the end of the script. So maybe to your point, let's get back on track. I love that line, healers of human conflict, and that explodes a myth that I have of the legal profession, right? What I know about lawyers is either from the people I know or from TV shows, Suits or something, right? Where it's just all a battle. It's a fight to the death and be ruthless and often immoral. That's the opposite of what you just presented as healers of human conflict. And you mentioned institutions. Runnymede is an institution. So why don't you share your thoughts on that as a segue? Runnymede institutions. Why do we need the institution that Runnymede Society is offering? You've already introduced that. It's to get students involved, but institutions shape us. They form a certain mindset or approach. And so what exactly are you trying to shape that people aren't already being shaped in during their studies? Go ahead.
Well, I think I mentioned before, why was Runnymede formed? And there were a few, voices out there saying, we are not paying enough attention to the rule of law in Canada. That was by 2015 or 2016. And individuals can have a lot of impact. A number of these people were esteemed jurists, lawyers, or even judges. And for a judge to step out at that point and cut against the grain is extremely courageous and should be commended. And so I guess the difference that an institution can make is it provides a very concrete and effective way for people who share the same concerns to find each other and then to organize and become effective at doing something about a problem that we all agree needs to be addressed.
So is it more than about the opportunity to influence change outside or within the broader legal community? At least that's what I'm hearing you describe Runnymede Society as existing for. Whereas, I'm thinking of Yuval Levin's latest book. If he ever listens to this, apologies for not remembering the title of your last book, but he's talking about how we need to be formed in order to be free. So we need to have the formation that happens within institutions. University is an institution. Our home is an institution. Sports teams, church, synagogue, they're all institutions that we may or may not be part of. We're all part of our family institution. But when I think of the Runnymede Society, or like Civitas, we were both at the conference, it's a institution that even if it does activist work or it doesn't do activist work, it's still a collection of people that, like to your point, are thinking a certain way. And I think there's a formation that happens there. So I learn something from you, you learn something from me. We walk away thinking a little differently. Is that something that Runnymede explicitly thinks about, or is it something that happens more by accident? You just get together, you're all concerned about similar issues, and so you have the opportunity to debate and discuss, and the formation part happens almost as a byproduct. It's a latent function. That's a good conservative philosophical term. It's a latent function of the institution itself. So have you ever turned your mind to that, about the way students change or develop or grow by being part of your society?
Yes, well, definitely. So there's a few dimensions to Runnymede in terms of how I think about how we're having an impact. And one of them is the network that I've kind of talked about before. So how many people are members? How many opportunities do we give people to meet, especially face to face? Twice a year for students who volunteer with us, been able to get funding to bring them all into the same place at once. And obviously I get to attend as well. And these are the highlights of my year, to see kind of, it's almost like we get to handpick people from different law schools who are concerned about constitutionalism, the rule of law, fundamental freedoms, good faith discourse, intellectual diversity, and they find each other. And I get to see kind of their eyes light up. I found my people. So it's really exciting. And so that's one part of it, is creating the network and a group of people where you're connected. And the way I think about this is, I guess we could look backwards and think of examples back in time where constitutionalism or the rule of law was under pressure. But you could imagine other types of emergency situations where the government is taking action. And what you want is the people who are in the legal community to have their alarm bells going off and say, we need to be talking about this. And it really helps if they know their people, if they're part of the network. But there are other things. You talked about the formation of lawyers and law students as well. So I think of Runnymede also as a venue for the exchange of ideas. So we have speaker events, we have a podcast. We're holding a symposium right now. We're recording. It's May 18th. So the symposium starts in a week. It'll be in Fredericton, and so that's a way that we gather some academics. This one is on Canadian constitutional history. So just to illustrate the ways that Runnymede is contributing to legal thought within its mandate. And so this is a way that I think people in the Runnymede network or our audiences or readers and listeners can expose themselves to ideas that they probably wouldn't be exposed to without Runnymede. So that's part of an intellectual formation. And the other thing I think about is, I guess, capacity or skill building. So I've noticed working with Runnymede volunteers, and even thinking about when I was a volunteer, there's a set of concrete skills where it really helps to be effective. And so, imagine you're a volunteer, there's some hot issue going on and it's not being debated properly. So things like knowing how to do a little bit of research to really get a sense of what the debate is, and especially what's missing from the conversation. And then researching who would be a good speaker to have come on campus, who's going to expose people to new ideas, but also engage with contrary views in good faith and be credible. We emphasize and actually require what I call rigor, which means speakers have to present their viewpoints with support so that people in the audience can independently evaluate what's being said. So these are all things that you have to kind of practice a little bit. And we've just started this year putting out these training videos to help our student volunteers get a little bit of a sense of what we've seen be successful. So I have this vision that eventually in Canada, there will be several dozen and eventually a few hundred students graduating every year, having been involved with Runnymede. They'll be part of this network. They'll have already been exposed to ideas that really make them sort of well-read and well-rounded in terms of understanding how these important issues at the bedrock of liberty in Canada play out. And they'll have the skills to actually do something when there's some controversy and there needs to be a discussion.
Yeah, brilliant. So you read my mind. I wanted you to, something that I mention probably too often is this idea of how our reason grows up. We're born with a capacity to reason, but that has to be developed. We're not fully rational beings unless we practice. That was a word you used. We have to practice and develop these skills. Aristotle, I'm not an Aristotle expert, I just like reading him, but he talks about intellectual virtue. And this is the idea that we actually, with time, effort, exposure, practice, to use your word, we develop intellectual virtue and an ability to think through topics in a way that may not be completely available or accessible in a classroom environment. And so that's what I see Runnymede offering, or institutions in general offering, when we talk about formation. The other, just before we leave this formation idea, the other example that Aristotle uses is the development of moral virtue. So if you want to be courageous, you become courageous by doing things that require courage. You're not born courageous. It has to actually be developed in you. And I think Aristotle makes a point that there's an analogous formation that's going on for our intellects and our reason. You mentioned rule of law a few times, and that was something I wanted you to dilate on, especially with respect to legal positivism. And this has been a huge hobby horse for me just in the healthcare community. It seems like every social problem will be fixed with a new bit of legislation, or we'll pass a new law and we'll ban wait times or something silly like that. So tell me, what is the rule of law? What is legal positivism? Maybe what are the good points of both? What are the limitations of both? So just take it away. Give us a lecture on the rule of law.
Yeah, so you probably understand legal positivism better than I do. So we can kind of go back and forth on what you understand that to be. But I think it does connect with what is the rule of law. And obviously it's one of the three core principles that Runnymede upholds. So it's important for us to know what it means. And I might just back up a little bit, because I think it's helpful to situate the rule of law together with those other two principles. So the others are constitutionalism and fundamental freedoms. And constitutionalism means that even the highest form of government power is subject to some supreme law. And so that's what it is. And we say that that's a good thing. We should keep that. And fundamental freedoms, we allude to the ones that are in Section 2 of the Charter. The heading there is actually fundamental freedoms. They're protected by a constitutional text. So they're supreme law. And they include freedom of conscience and religion, thought, expression, belief, opinion. A lot of people don't know you have a constitution, freedom of opinion, and to express it. There's also freedom of association, freedom to peacefully assemble, and freedom of the press. So those are fundamental freedoms. And so returning to the rule of law, this is a principle that the Supreme Court of Canada has described as having a few different facets. So one of them actually came up in a case in Manitoba, where there was a constitutional challenge to the fact that a number of the laws of the province weren't being translated into French and English, or presented in both languages. And the court was convinced that the province was actually constitutionally required to have both languages as versions of their laws. And so the question came, well, what is the remedy? Do we just say all these laws have no force and effect? And the court said, no, we're going to allow time for the province to actually promulgate laws, both languages, because one of the facets to the rule of law is that there has to be an actual system of positive laws. We can't have a lawless society. Other facets to the rule of law are that the relationship between the state and the individual must be strictly governed and regulated by law, because if it's not, then you'd end up with arbitrary use of state power, including judges making arbitrary decisions. And people may remember the case of Roncarelli against Duplessis in Quebec, where the premier ordered that Roncarelli's liquor license be revoked based on his support for Jehovah's Witnesses who were being prosecuted for distributing literature. That's not a valid reason to cause somebody's restaurant to go under. So that's sort of a well-known decision to illustrate that point. Other facets include one that people will recognize, the idea that no one is above the law. So the law is supreme over the actions of private individuals, but also over the actions of government, which is where we come back to this idea about the supreme law. And another facet is connected to that one, which is access to justice. So there was litigation in BC a few years ago now. The legislature decided to try to recover some of the costs from running courts by imposing fees. If you bring an action to court, you've got to pay to cover some of the costs, depending on how many days you'll need in court, and so on. And this was ruled to be unconstitutional because it would stop some people from being able to actually enforce their rights. And if you can't enforce your rights in court, then do you really have them? So these are the different dimensions of the rule of law. And I guess that another question that's important to ask here is, and I think this is sort of the type of thing that legal positivism grapples with, is you have laws on the books and they've been passed according to, the processes that we agree have to be in place. They're promulgated. Should everybody obey every law? And even, suppose you're a judge interpreting a law. Are there some laws that are immoral? So how to grapple with those questions. And I think this, just a couple of thoughts I'll share. Maybe we can go back and forth on this a little bit. I mentioned the freedom of conscience, which has constitutional content. I think that has powerful moral content as well. And there are cases where people decide not to a law or a rule or a policy based on their conscience. You have available to you a course of action in civil disobedience or conscientious objection. There were religious groups in I think it was the Second World War who objected to being drafted on conscientious grounds. It's an example. And the way I think about it is, if someone objects, they could follow a process to go through the legislature or bring a court challenge and change the law, or they could object, and we might be persuaded that what they've done is moral, but at the same time the law has to be enforced, so they may have to face consequences.
Yeah. So I hope I'm not cutting you off by jumping in here
No,
now.
not at all.
Beautiful. So I'm glad you offered at least touched on the complexity and nuance packed within this thing that's so easy to say, right? Rule of law, rule of law. We believe in the rule of law. But when you talk to people, oftentimes they have an understanding that the rule of law means there's a stack of laws written down somewhere and they all have numbers, and it just is a matter of us following all those numbers. But there's also an even more difficult and more nuanced understanding there. And you started touching on that. Well, what does it mean to have a law if we've agreed that the laws need to be in both languages, and yet we're in a period now where we don't have them in both languages? Does that mean we have no law? What happens in that interregnum? Are we a lawless society? And you mentioned constitutionalism a number of times. The English Constitution goes back way before 1867.
Yes.
1867 is just one bit of legislation in our much larger constitutional approach, or the 1982 Constitution Act. And so I think it's important for us to grapple with this sense, or the example I use, and then I'll be quiet and get your reflections on it. The example I use, and I'm not sure if this is a great example, but this is how I try to wrestle with this concept of the rule of law as being something different than the actual laws that we write down. If you imagine you and I walking along a single lane path or a single lane bridge in Ontario, or we're in England,
Yeah.
right? We're driving over a stone bridge and it can only hold one car. And you and I both come screaming at it. We're both late for work going in the opposite direction. How do we decide who gets to go? And how do we decide who's in the wrong if the other person doesn't move? Is it by how big your car is? Is it by how expensive your car is? How far up the bridge you are? Or is it the age of the driver? The older person gets to go first. So all of these things that we already have a sense of how it's supposed to go. Roger Scruton's favorite word is, we're a society of strangers. connected by a shared sense of manners. So rule of law almost starts getting into norms and manners. It touches on morality as well, and we can talk about that. But I'm not saying it's just morality. It's not just about right and wrong, but it's about our sense of how things should go. I guess that's morality. But now to try to take the example of who gets to go first when you're crossing the bridge and put that down into black marks on white paper into an actual law is incredibly difficult. And how do you write out all the exceptions and all of the particularities of the scenario, how it should go? And this is why we have lawsuits. This is why we have judges trying to say, yeah, no, Tim, you were clearly in the wrong. You should have let Shawn go over the bridge first, for whatever reason. So that's where I'm trying to amplify or to get your thoughts on the rule of law. It seems to me sometimes people are using that term, the rule of law, to indicate we have a bunch of laws and we just need judges to follow those laws that are written out, versus the rule of law as a philosophical concept of this idea of lawful behavior, which seems to go beyond, or perhaps we can use the word transcends, what we are able to actually capture in writing. It's not to say that what we capture in writing isn't lawful or it isn't a good law. Sure, that's why we write laws. But often what we write can never fully capture what we as humans understand to be a lawful conduct. Now, have I totally butchered the rule of law, or what are your thoughts on that?
No, those are excellent questions, and I would I think one insight that's important is the distinction between legislatures and courts as institutions, and these are different orders of government. We have the executive, the legislature, and the judiciary. And so to take your example, two people are crossing a bridge at the same time. We need to figure out who has the right of way. If you're writing down a law that only deals with that particular controversy, you could probably do a pretty good job, because you could take into account everything that's relevant in that particular case. And that's what judges do. So if you think about our common law tradition in Canada, the idea is that individual cases come before the courts, and the judge decides the case based on what happened there. And then eventually, as cases come forward, you end up with sort of overarching rules or principles that can help judges in future cases decide like cases in like ways. And that's sort of the common law logic. At the same time, you have legislatures where you have to write down laws that have general application, which means you can't, I guess you could try to capture every specific thing that can happen in different cases, but generally these laws have general application. So that's why we still need courts to interpret the laws when there's some controversy that comes up and the parties can't sort it out between themselves. So they need a court to tell them how the law, even though it's written down, applies in the particular case. So these are things to think about in terms of institutional capacity and institutional role. Sometimes legislatures don't go very far into specificity. So to take your example, they might say, two cars are on a bridge, neither driver shall be unreasonable or something. That's very helpful. And in that case, judges will have a lot of work to do to figure out, well, what is unreasonable? Or they could set out, the determining factor is the age of the driver or something, where it's like bright line rules and you can clearly see who's right and wrong. But even if they do that, then there may be cases where there's some other factor involved. Maybe one of the drivers is injured and on the way to the hospital, and the legislature hadn't thought about that. But if you think about like moral judgment, the answer that the law says in that case is actually wrong. So what we also get into is how thick is the rule of law? I've heard it put that way. So one way of thinking about the rule of law is that it just requires judges to apply the law as it's written, and to really try to discern the intent of the legislature and sort of go no further and expect to be able to find the answer using a methodology of what judges do, I think this is in the tradition of legal positivism, in a way, that there's some methodology, and the judge doesn't have to really engage in independent moral reasoning, or at least not much. So that's one view of the rule of law. But there are others. There are those who say that there's sort of natural law, or even this idea of the common good underpinning the law, and that judges need to be filling in blanks based on what is really a discernible moral tradition. You could put living tree progressivism in that family as well, where the idea is that judges should be deciding cases in a way that pushes Canadian society towards a more progressive world, and there's specific values that are connected to that. So just a couple thoughts, riffing on everything you said. Could probably talk for a long time.
No, this is brilliant. This is brilliant, and I like to. I'll grab a hold of the word you used, interpretation. Yeah, interpretation, and you get into institutional capacity and competence, and it's overlaying there. And it made me think of 1993, I believe it was, Rodriguez case. No, physician-assisted suicide is still illegal, and we'll uphold the criminal code on that. 2015 Carter case. Oh no, clearly it is a bad bit of criminal code. We need to get rid of that and tell the legislature to write new legislation, or write a new law on how not just physician-assisted suicide, but voluntary active euthanasia is going to be done in Canada legally. And so we have the opposite opinion, legal interpretation. We'll use your word, interpretation. And what is it based on? And what kind of, so we sounded like you were talking about different concepts of the rule of law, whether it's legal positivism or natural law or progressive based, and what guided people in those two decisions. It sounds like they were trying to have laws that reflect the sentiment within the population. I think that's what they were doing. They may have been doing the progressivism notion that you shared, but the reason why I think it's important for us to chat about this and dilate on this is because this is going on all the time, and we just see a headline. We see a headline about free speech. We see a headline about the notwithstanding clause, the Supreme Court challenge to Quebec's Bill 21. Is that correct?
Yes.
Yeah, repeated use of the notwithstanding clause. And if we don't think about what's informing those judges as they make their decision, what's the philosophy, what is informing their interpretation, then we might be surprised and upset. But I think it's really important. I'm not sure I can articulate why I think it's important, but I think it's crucial that we spend the time thinking about the different ways that the judges could be approaching this issue in their own mind, as opposed to just saying, well, that's right and that's wrong and they're stupid and we're smart. It's more than that. There's actually fairly substantively different philosophical approaches that we need to be asking as citizens. Well, is that the kind of country we want to be in? Do we want to be in a country where our courts are making decisions armed by, what was the term you used about progressive law?
Progressive living tree. So
right.
Living tree is specifically in constitutional law. It takes from a 1929 decision from Privy Council. It's commonly called the Persons case. At the time, we had the Supreme Court of Canada, but you could appeal from the Supreme Court and have a decision from sort of a final court of appeal, being the Privy Council in Britain. And here, this was a decision that found that the word persons in our British North America Act, as it relates to eligibility to run for the Senate, included both male and female persons. And if you read the decision, it is a very methodical exercise in interpreting the statute. What did the drafters of the statute intend? And the conclusion was persons means men and women. But there's a passage in that decision that says about the Canadian legal tradition that it was planted as a living tree capable of growth and expansion within its natural limits. And for whatever reason, some have latched onto this idea that, well, it's a tree, it starts out as a sapling or something, and it could become, judges have lots of latitude to expand the law. So that's where that term comes from and how it's used.
Brilliant. Well, thanks for bringing that in. I better get back to our plan here. We talked about rule of law.
Sure.
Oh, yeah. Can the law be neutral? And then I also want to talk about your case. So maybe we'll just ask you about the neutrality of the law. Perhaps you can even talk about the concept of neutral proceduralism, because it relates kind of to what happens in the legislature as well. I didn't warn you that I'd ask you that question, but if you want to comment on it, go ahead. And then with that question, we'll wrap up sort of the official Runnymede spokesperson comments, and then we'll get into your case, and we could make a brighter line in the podcast between, okay, this is Runnymede stuff, and this is now just Tim going to court. Go ahead.
Thank you for helping me draw that line. So on, you said, can the law be neutral? I think immediately of the law of against discrimination, because there are different schools of thought here, and this is absolutely a live issue in Canadian law. In human rights tribunals, this comes up, but it's also part of our constitutional law because the Charter Section 15 deals with, some might call it non-discrimination, and that would be sort of a narrower, maybe more formalistic view. And some would use words like substantive equality. And there's a more extreme version of substantive equality that wants to sort of think the law should be engaged anytime there's a difference in outcomes between different groups, when you define those groups based on protected characteristics like race or sex or gender identity, is now included in our human rights codes across the country. So the narrower view says, laws can prohibit against discrimination, and that's a neutral law, and so it's acceptable. And the example that I've heard before is, okay, if you pass a law that says you cannot sleep under this bridge, somebody has a place to sleep. The law basically doesn't affect that person. They weren't thinking about sleeping under the bridge to begin with. But someone whose economic and social situation is such that they don't have their own bed, under a bridge is maybe the best option they have to have kind of a secure sleep, protected from the elements. So some say, okay, you have a law that you say is neutral. But is it neutral? Because you have to consider the way that people are actually affected by law. And one case to look at is a 2020 decision by the Supreme Court of Canada called Fraser against Canada. And this was one where it has to do with the RCMP and their pension plan. And I don't remember exactly the detail. It's sort of can't quantify how much it made a difference exactly. But what would happen is there was a job sharing program where it allowed you more work-life flexibility, essentially. But if you opted into that program, your pension entitlement was less generous. And the crux of this challenge was, women in the workforce were overwhelmingly the ones who were electing for this program. And so you have a law that is neutral in a sense, because anybody can opt into this program, and if you do, your pension entitlement is less attractive. But women are choosing it more because they more often have childcare burdens at home and so on. And the court actually said this pension program is a violation of Section 15 of the Charter. So critics of this would say, well, now you're requiring the RCMP to have a differentiated program based on gender, and that's discrimination. So this is kind of the type of debate that we're in. So when you ask about can the law be neutral, I think it might be helpful to just set out that debate on non-discrimination or substantive equality, depending on how you look at the issue.
Yeah, brilliant. No, that's beautiful, and it ties into a theme that's been rolling around in my head for several years now. that at some point you pick a side. At some point you say, well, we're a Western democracy, and this is what we've always done, and this is what we think is normal. You don't fish salmon when they're spawning. You don't drive over ducklings and their mother when they cross the road in the spring. Like there are just some things that you don't do. And I'm not saying that we're the only country in the world that doesn't do it, but there are differing opinions on what you can and or what you should and shouldn't do. Again, not just to be moralistic about it, but to base it more on the particularities. That's another hobby horse I've had, universalism versus particularism. I do want to spend some time, though, hearing about your case. So feel free to make a comment on that bit of rambling mush that I just shared, or we can jump straight into your University of Saskatchewan case.
Well, I've been loving this conversation. I think that's all I want to say is I'm inspired and I really admire the way that you're thinking about these issues. Because they are important, and there aren't that many people who think deeply about the law. Where does it come from? What makes it legitimate? Should people follow it? How does it match up to or compare with good morality? And so if I may just make a little plug here as we're going for the Runnymede Society. Right now we're recruiting for students to volunteer with us and lead a chapter at their law school or their pre-law undergraduate program. Coming up in the fall. So if you're listening to this and you're a student or you know somebody who might be interested in joining this excellent network, getting involved in an really important dimension of your formation as you head towards the legal profession, get in touch with us. If there's a Runnymede chapter on your campus, get involved with them. If there isn't one, get in touch with me and we can talk about forming one. So that's my plug. And yeah, other than that, I love these types of conversations, and it's so special to be fostering a network of people who are really passionate about these questions. And other than that, I think you've given me my cue to talk about this legal case in Saskatchewan. So this is in my personal capacity. I think it does make sense to connect it to the conversation we've been having so far. Because if nothing else, I guess people will see how my personal journey has taken me through getting embroiled in this case with the university, as well as sort of promoting civil discourse and lawyers as healers of human conflict, including the toughest ones. So what happened? Basically, while I was in law school, I think I mentioned before, I had a sense that there were certain sacred cow topics that are tricky to get into. And something else I encountered while I was in law school is what at the time I was calling race scholarship. And it was it was included in some of my course material, and I basically just wasn't buying it. And my critiques of this, what I'll describe more specifically later on as the story goes on. What I wasn't buying about it was it had sort of a pretty simplistic narrative framing about justice in society. Virtually every issue is a race issue, and there's two different categories of people. You can judge them morally based on whether they're sort of in the racial oppressor category versus the oppressed category. And one of the things that actually really bothered me was I like to understand things in as much detail as I can. I like to measure things or find ways to test my ideas against what other people are thinking or what's really going on, because that's a good way to learn. And in this race scholarship, I wasn't seeing epistemological humility, I guess would be the term, or empiricism. So I wasn't buying it. And I also thought it was kind of a problem because the message for people who would identify in the racial oppressed class was a very dramatic and alarming message. It was basically that Canada's institutions are against you. This is a terrible thing. It's the cause of most, if not all, of the difficult things you experience in life. And at the same time, maybe just because of methodological shortcomings in this area of scholarship, it didn't really have answers. It didn't have ways where, if you're in this oppressed group, here's what you can do to improve the situation. So it's kind of a hopeless message. And this all became very relevant because there had been, when I was in my third year of law school, this controversy over how students were being evaluated. So some students had estimated that, I don't know if this number is accurate or not, but this was the discussion. They'd estimated that as many as a third of the students in law school were getting extra time on exams. And this came to be connected to race issues because there's a policy that made extra time available to students who self-declared as Indigenous. And I was quite taken aback by the level to which that, just the suggestion that students should talk about that issue really created factions. And I was able to talk to people on both sides and really I just listened because I was trying to make sense of why this was such a hot issue. And I was kind of struck by, I sensed that people sort of had daggers in their eyes when looking at people on the other side. And I thought that was alarming. So I decided to do something about it. So one of the things I did was I wrote a 7-page letter to a handful of faculty members that I thought would be interested in my, it was like a layperson's critique of race scholarship, because I sensed that there was a connection between that message and how students were relating to this controversy. And the second thing I did was I wrote a 3-page letter and read it aloud. I got a spot on the agenda at a meeting of the Law Students Association. And that letter was a defense of courageous dialogue, including specifically in that controversy. And this was very offensive to some of my classmates. They brought disciplinary proceedings against me. So we went all the way through the process with the university. It was a harassment complaint. And so the idea was that by encouraging dialogue on this issue, I was harming people, essentially. And I think I have better insights now on how students believe that than I did at the time. Going through the process at the university, I was often quite puzzled by how that allegation was being taken seriously, to be honest. But it was, and I was found guilty of non-academic misconduct, specifically for circulating the letter to my classmates. And I went all the way through the proceedings with the university, and at the appeal hearing, which was the final stage, counsel for the complainants made these references to decolonization, and that the university's overarching plan document includes a commitment to decolonization. And I thought that was totally irrelevant when I was in the hearing, but it appeared in the sort of summary of the complainant's position in the written decision, and that sent me down a rabbit hole, which was very relevant to my case. And I really wish this had been disclosed to me at the beginning of the proceedings. But basically, the story is at the University of Saskatchewan. Some of us will remember 2020 and the killing of George Floyd, and people call it the George Floyd summer. There were a number of protests, and this came to the University of Saskatchewan, and there were a series of statements and commitments from the university about combating racism. And what the university did was they appointed the head of an anti-racism, anti-oppression committee, and gave that committee pretty vast authority. One of the things that committee did was start to do training, and they developed an 8-module training program, which they eventually posted online, and which we include in our materials in this legal case. And there were also, over the months and years after the summer of 2020, amendments to certain policies of the university, and also new policies. And one of the new documents that was put out by the university was called the Indigenous Strategy. And this document was incorporated into a 5-year university plan, which was already in place at the time. But one of the things that the Indigenous strategy said was that the university is committing itself to ensuring the safety of Indigenous people on campus. And the way it's doing this is by undertaking education in anti-racism. But if you look at the glossary of that document, anti-racism is a defined term, and it's roughly the thing that I didn't agree with is race scholarship. It's a particular approach that says it's going to fight racism. To this day, I'm not persuaded that it does. I don't think it's even capable of it. But in any event, after I've already gone through the appeal process with the university, I'm discovering this, and there is actually in Saskatchewan the ability to add materials to your application when you go to court. It's a judicial review application. That's what we've been able to do. We also have to hire an expert to sort of explain what is the content of this institutional commitment. Our expert is Dr. Eric Kaufman, who classifies this as falling under the school of thought called critical social justice. And this includes two tenets, two beliefs. One is that if a member of an oppressed racial group makes an assertion that they've been subjectively harmed, this cannot be questioned. That's one. And the other is, so I alluded to before in our conversation as sort of the radical or extreme version of substantive equality, which is that if there's any disparity in outcome at the group level, on average, between a racial oppressed group and I guess the general population, this is because of white supremacy. There's no interrogation into, are Indigenous people more likely to be in a rural area and that type of thing. It must be white supremacy, and the disparities have to be eliminated. So the argument we're making, which is ambitious, I've not seen someone make this argument in court, but the argument is, how could someone hearing my case, when the university is pushing this so strongly, training people in it, telling them they have to adopt it, how can someone decide my case where the only witness is an Indigenous student speaking on behalf of her peers and saying they've been subjectively harmed? One of the tenets of this belief system is you can't question that. And then the other part of my case is, was it wrongful for me to say people should debate an affirmative action policy? And an affirmative action policy responds to white supremacy, according to this worldview. So it is wrongful to want to debate whether white supremacy is okay. It's essentially what follows if you're in the world of critical social justice. So I think it's a very important case, not just for me. I think other universities have done similarly to what the University of Saskatchewan has done, and we're not talking about this enough. I think that's all I'll say to wrap up.
Wow, I had no idea that you're up to your neck in the alligator pit. That is, it gives me chest pain just listening to your story. And the thing is I doubt you had any clue what you were walking into. Probably, I imagine if you knew all of this in the start, you probably wouldn't have put anything in writing and just said, "Oh, I'm going to duck that bomb. I don't want to get caught there." But it's so painful to hear you share that, because although you're very calm and relaxed and you've shared it in a factual, thoughtful manner, I'm just thinking, gosh, the number of sleepless nights that this guy probably had to deal with in this whole process is, just brutal. So we certainly hope you have a good outcome with that case. Crazy.
The wheels of justice turn slowly. We're now 2026, and I graduated in 2022, just to give people a sense of how long this has taken. And there were some sleepless nights of stress and frustration and other things. But I don't know, maybe it's just, enough time has passed. I've been able to kind of work through some of that. I do respond to the very first thing you said, though, about if I knew what would come of this, would I still have spoken up? I actually think I would have. It's sort of, maybe it's hardest on the first person who takes a step or sticks his neck out. But I really think more people need to be talking about this, and I hope that this case will, it'll force a judge to look at this, and maybe people will write about it. But I hope members of the public think more and talk more about this as well.
Yeah, no, for sure. On second thought, I'm thinking we should have just had the whole podcast just about this. And I apologize, I didn't know enough of the details, but I did try to sneak it in earlier in the in the hour. So, but you were smooth enough to say no. Let's just focus on. Anyways, so well done. Kudos to you. The last question I always ask everybody is, what should I have asked you about? You already told us what's keeping you awake at night, or it's not keeping you awake any longer. But where have I completely missed the boat? So if you were writing out questions that I should have been asking you, what should I have asked you about?
Oh, I think you've stumped me because your questions were so good. Um, I guess, maybe we could talk more about some of the ways in which discourse is being limited on campus. And I guess I stumbled into an example there. My sense is this type of enforcement of unorthodoxy is extremely effective in universities. And there are taboo subjects that aren't just sort of coming to be taboo subjects naturally, if you want to put it that way, kind of from the bottom up. I'm convinced that universities and as institutions are creating taboos and enforcing them. And as I said a moment ago, it's the type of thing I think we need to be talking about more and researching and learning about.
Yeah, well said. I'm going to have Josh Mitchell on podcast in a few weeks. He makes the argument in many, many podcasts and in his book, in his writing. He's written many books, but his last book I'm thinking of, American Awakening, where he says that we probably haven't seen the end of this trend. Mitchell would argue that we haven't seen the end of this, and he thinks that it will actually get probably a lot worse before it gets better. Piers Morgan wrote a book saying we're past woke or something. I can't remember the title. I'll find the title and maybe put a picture of it on the screen. But he said, oh yeah, no, we're past woke. Sanity's returned. We're back to, a neutral liberalism. At least that's the sense I get from him and the sorts of things that he promotes. But Mitchell would say, yeah, no, I don't think so. It may have cooled off a wee bit, but the logic behind this push will it'll continue on the same track that it's been on. And so we'll see more of the cases you're talking about. We'll see more a limitation on dialogue and speech at universities. And it may get uglier before it gets better. So this is a crucial issue, and it's a good way to close. It looked like you were taking a breath to say something. Is there something you wanted to add to that?
Oh, well, I'll look forward to that podcast episode with Josh Mitchell.
Yeah.
I guess the overarching point that made me think of is that we have inherited this wonderful constitutional legal tradition in the span of all human history around the globe. I don't know that I would trade it for another, but we have to protect it.
Yeah, great way to end. Tim, thank you so much for making time for this, and I look forward to, maybe we'll have to have you back when that case resolves. But anyways, thank you for making the time today.
Thank you, Shawn. It was great to be here.